Very good.
Hi everyone, welcome back to Common Denominator. My guest today is Professor Herbert Hovenkamp, the James D. Dinan University Professor at the University of Pennsylvania Carey Law School and the Wharton School. Professor Hovenkamp is the co-author of Antitrust Law, the most comprehensive treatise on the subject in existence, written alongside the late Philip Arita. It is the text that federal judges, the FTC, the Department of Justice, and the Supreme Court of the United States have cited as authoritative for decades. And if there's a single work that defines the intellectual infrastructure of American antitrust law, this is it. And over a career spanning more than 50 years, Professor Hovenkamp has produced scholarship that covers the full arc of antitrust, from its origins in the progressive era through the Chicago School Revolution of the 1970s and 1980s, and through the emergence of platform economics and digital markets, and into the current debate over what antitrust enforcement should look like in the 21st century. His work has also focused on a dimension of antitrust that rarely receives serious attention in public discourse, the relationship between competition policy and the welfare of workers. What distinguishes Professor Helmenkamp in the current moment is a refusal to belong to either side of the debate that has become increasingly polarized. He has been a sustained critic of the neoliberal Chicago School framework, arguing that it embedded a distorted conception of consumer welfare that systemically ignored harm to both consumers and labor. But he has been an equally rigorous critic of the neo-Brandeis or anti-monopoly movement, arguing that its hostility to economic analysis and its reliance on outdated doctrine has made it incapable of producing the enforcement outcomes that it claims to want. It is a method, evidence, measurement, and an honest accounting of what markets actually do to real people. So thank you so much, Professor Hollenkamp, for joining us today in Common Denominator.
My pleasure. Thank you.
So I'd like to begin with something foundational because I feel like it'll frame everything that we're going to be talking about later on. So in your articles, I've noticed that you've observed antitrust law through more cycles of reform and retrenchment than any other scholar working today. So when I was researching other people, I didn't really see it through that lens that you have, like the aggressive enforcement of the 60s and 70s, the Chicago school contraction in the 80s, as we mentioned before, and now the significant expansion of enforcement ambition in the present moment. You have been critical of each phase, as I mentioned before as well, for different reasons. So before we examine any of the specifics, in your view, what does antitrust policy sound like and look like? And what should it actually try to accomplish? And when do you know it's actually working?
Uh, well, first of all, antitrust is distinctive from a lot of other bodies of law in that it is not primarily concerned with the distribution of wealth or with poverty or inequality. We've got lots and lots of statutes that do those things, both tax statutes and employment facilitating, pension supporting statutes, and so on. Antitrust is concerned with things that make the market more competitive, which means prices that are close as possible to cost, uh, output that is as large as is reasonably sustainable, and the absence of any restraints on innovation or productivity or product quality. So it's concerned with the overall size and health of markets rather than with the way that wealth is distributed in those markets.
Thank you so much. And I really liked how you mentioned like something that I've seen in your articles as well, like the definition of this goal, like it should be competitive. So you're producing higher output at lower prices and it'll benefit both consumers and workers. That's something that I've realized that you mentioned as well. So it's something that we should hold on to moving forward because the next question I have concerns like a movement that shares the stated goal, but you have argued that it is systemically undermining through its means that it's chosen to pursue it. So, in your essay about antitrust metrics, you write that the anti-monopoly movement relies instead on the 60-year-old doctrine, making the movement one of the most aggressive in antitrust jurisprudence. And you draw a comparison to the 14th century monks who resolved every serious question not by examining the world in front of them, but by consulting Aristotle. That is a deliberately pointed critique of a coalition that regards itself as progressive, pro-consumer, and pro-worker. The charge you are making is not that their values are wrong, but it is that their method is incapable of achieving those values. So, can you develop that argument and what specifically breaks down when antitrust enforcement is not grounded in economic measurement?
Well, the problem with the anti-monopoly movement is that it has always been a reaction to major changes in technology. Uh, it occurred during the progressive era uh, in response to the rise of large industrial firms like Standard Oil, U.S. Steel, American Can, DuPont, and others. It occurred again in the 1930s in response to the revolution in retail distribution that occurred, moved us from single store operators to large organizations like Macy's or Kroger's or Costco that own lots of stores and have their own distribution networks. We saw it a third time in the hostility towards the digital revolution promoted by IBM in the 1960s when IBM moved from analog calculating machines to digital computers, and the United States filed a major antitrust lawsuit against it. And then finally, we're seeing it today in the hostile reactions to uh, large tech firms that operate on the internet, like Amazon, Apple, Alphabet, Meta, Microsoft, and so on. So one way to generalize about the anti-monopoly movement is that it's really a reactionary uh, approach to developments in new technology that generally make all of us better off. They're good for consumers, they're good for labor, but they displace a lot of older politically powerful interests. And those interests still have a major voice in the political process, even though they have lost out in markets. And that's why I'm suspicious of the anti-monopoly movement. It it it's it uses an anti-economic definition of monopoly. In fact, it has a very poorly defined concept of monopoly. In economics, we think of monopoly as bad because it yields higher prices, reduced output, and restraints on innovation. Well, a lot of the so-called anti-monopoly movement is actually an attack on low prices and highly innovative markets. Those tech companies in the crosshairs today, like Alphabet and Microsoft and Apple, they're among the most highly innovative companies in the world, and they also give us a whole lot of stuff at very low prices, including frequently prices of zero.
I thought it was really interesting how you mentioned that there's an economic definition of what a monopoly is, and there's one that has been curated today through this I guess political discourse that's happening about anti-monopoly like mindsets and everything. So I thought it was really interesting how you mentioned that. And I feel like it shows up how like when courts are defining markets, which are the foundational question in almost every antitrust case, when it's what they define what a market would be and how a monopoly would be working like. And you've been very particularly direct about one framework that courts have relied on for more than six decades, arguing that its continued results have produced like things that are analytically indefensible, in my opinion. So I think something that you mentioned in one of your articles was you write that the brown shoe factors, the Supreme Court's 1962 framework for market definition in merger cases are wrong in most cases because they persist, not because they work, but because of the superior analytical tool. The hypothetical monopolist test requires pricing data and economic analysis that courts cannot always access. And you're saying that it's a structural problem. The best available instrument cannot always be deployed, and the fallback is one that you considered deeply flawed. So, what does enforcement look like in this gap, and what do you think it costs?
Well, the problem with the brown shoe case was that the evil that the court recognized, this was a merger between two fairly large shoe manufacturers, uh, And the court condemned it not because it threatened higher prices or lower quality shoes. On the contrary, it condemned it because the merger promised lower prices and higher quality shoes. And as a result, the court said the merger was bad because it would knock out of the market or would injure competing firms that were not big enough to take advantage of those things. And so today we would regard that as a very perverse reason for condemning a merger. We want mergers to yield lower prices, higher quality, and yes, occasionally the large firms that mergers create do injure smaller rivals, but it's not an antitrust job to protect smaller or obsolete technologies from being knocked out of the market by something that consumers prefer. As a result, my view is that the goal of antitrust enforcement ought to be really to track two big interest groups. One is consumers and one is labor. And what both of them have in common is that they are benefited by larger, more competitive markets that produce more. They tend to do that when the prices are close to cost. And overall, they tend to benefit from high levels of innovation. Uh, and that's where antitrust should be heading, as opposed to brown shoes, rather backward condemnation of a merger simply because it was producing a better product that was killing off older rivals.
I also noticed how you mentioned that it's not antitrust law's job to protect these smaller businesses or businesses that are trying to enter the market. So who do you think is responsible for these groups or individuals?
Many, many other parts of the legal system. We have a small business administration that protects small business. Uh, we have tax laws that give tax incentives to small businesses. Uh, there's a variety. There's a variety of legal tools. In fact, antitrust is rather unique in the legal system in that it is uh, concerned exclusively with making markets more competitive, not with subsidizing one particular group uh, by charging more or putting pressure on a different on a different group. So the antitrust does not make a general kind of neoliberal claim that all of the economic world needs to be governed by free markets. There are plenty of people who believe that. Uh, but the antitrust view is a whole lot narrower, which is that antitrust law is governed by its concern for the protection of free markets. And it does so acknowledging that there are plenty of other regulatory provisions in the statute books that protect these other things.
Yeah, that was a really great insight. I feel like that's something that people really forget when kind of attacking the issues or maybe the issues of like the anti-monopoly mindset. So something else I noticed is that
There's a big incentive, particularly on the part of the lay
Mhm,
people, to
mhm.
kind of globalize antitrust and make it kind of the key to the entire economy. But it was never intended to be that. It has always coexisted with other statutory regimes, of which we have many, both federal and state, and and it does what it does within its domain.
Yeah, that I think that's exactly right. Like whatever you just said, like with making it stay within its domain and allowing other systems and other parts of our legal system to kind of control whatever's happening right now within the rights of small businesses or like individuals who are trying to enter the market. I feel like that should be delegated to them instead. And something
That's
else that I
exactly right.
noticed, yeah. And I think something else that is very important that you have written on before is how I think I'll just use a quote that you had written. Both antitrust's neoliberal right and its progressive left have advocated policies that are harmful to labor. And the mechanism that you identify here runs through product markets rather than labor markets. So something that you mentioned before, particularly that it should be helping both labor and also consumers. Your argument is that the demand for labor is a derivative of product market demand. And that when antitrust policy suppresses output, whether through under enforcement that permits monopoly or through over enforcement that eliminates productive efficiencies, workers absorb that reduction in direct proportion. You further note that workers in the United States currently receive on average 65 cents for every dollar of value they produce, a figure that implies monopoly power is already persuasive and severe. So given this baseline, where does antitrust enforcement need to focus if the genuine interest is in protecting labor?
Antitrust needs to do at least three different things to protect labor. One is rigorous enforcement of employer cartels, that is, agreements between employers to keep wages down. Those should be illegal per se. I give a lot of credit to the Neo-Brandeisians for standing behind that proposition and enforcing it. Secondly, they have to police non-competition agreements, which are basically agreements that employees frequently make that limit their ability to move to competitors. Those can also be very anti-competitive. Thirdly, and this is where I think the Neo-Brandeisians fall down, is they have to remember that healthy labor markets depend on healthy product markets. As markets produce more, as the number of goods they produce is greater, the amount of labor they use is greater as well. And as a result, competitive markets on the product side yield competitive labor outcomes on the labor side. And I think it's of all of the things that antitrust can do to protect labor, I think that particular one is the most important because it affects all workers, while labor cartels and non-compete agreements affect only relatively small percentages.
Yeah, so I really thought it was interesting how you mentioned that healthy labor markets, they depend on healthy product markets. And right now I feel like everything that you described is a situation in which the direction of enforcement matters as much as its intensity. So where action is when it's in the name of competition, can produce outcomes that are indistinguishable from the harms that it was meant to prevent. And I thought it was really interesting how you mentioned that labor markets should be something that we focus on, but it's not something, it's a really small percentage of what's actually happening. So I feel like in your writing and the way you've spoken, you've formalized this in a way that deserves direct attention because it has implications on how we like evaluate the enforcement record for the past couple of years. And you also describe the relationship between antitrust enforcement and market output as an inverted U shape, with a point of optimal enforcement in the middle and symmetric damage on each side. So you write explicitly that too much antitrust enforcement leads to surprisingly similar results to too little, and that over enforcement may lead to smaller firms, but both consumers and labor being sufferers. You cite the JetBlue Spirit merger as a concrete illustration, noting that the court that approved the injunction blocked the deal, acknowledging that benefits of that merger were very likely to exceed the costs, and argued that on the basis that it should be classified as a failure of merger policy rather than success. So how do you think policymakers and the public should be evaluating enforcement decisions, and what metrics would actually tell us whether the current posture is producing good outcomes?
Well, that's a very hard question. In fact, that's probably the hardest question that antitrust policymakers have to deal with. Merger law is particularly important because the great majority of mergers in the US are pro-competitive. They produce higher output, often lower prices, better products, and that's because mergers take advantage of uh, complementary relationships between firms. Firms acquire other firms in order to do better in a certain market. Okay, there is a subset of mergers, however, that are anti-competitive. We only challenge less than 1% of the mergers that occur in the United States. I mean, this is not a new thing. The government knows that most mergers are either pro-competitive or competitively harmless, but we single out a small number of mergers. The neo-Brandeisian movement was way too hostile towards mergers. In fact, sometimes even suggesting that there weren't any such things as efficient mergers, but there's absolutely no economic evidence for that. Most mergers are beneficial, and the important goal for antitrust policy is to get merger review correct. And that is a very hard thing to do because a merger is harmful when it results in higher prices, lower output, or reduced quality or innovation. Furthermore, we make those decisions before the merger has actually occurred. Almost all of them today are made before the merger has occurred, which means that we have to rely on prediction rather than observation, and that makes merger policy doubly difficult. Nevertheless, the importance of getting merger policy right, which results in maximum output, is hard to exaggerate.
Yeah, I think that when you mentioned that mergers are supposed to be pro-competitive and there's like a difference between those that are anti-competitive and pro-competitive, and you mentioned that it's harmful, like something that you've kind of echoed throughout like this interview and everything that you've written before, is that it's harmful when it reaches higher prices and reduced output. And I feel like that really centralizes what exactly we're supposed to do within the economies, like to have products that are beneficial towards consumers that have lower prices and higher output. And my last question towards you would be on your essay on antitrust metrics again. So you close your essay with what reads as conditional, not dismissal of anti-monopoly movement, but challenge to it. You write that if the movement is to have a future, it needs to abandon a dogmatic, backward-obsessed populism and engage seriously with measurement of competitive effects. The conditional is doing significant work there. You're leaving open the possibility that movement could evolve into something analytically credible. What would that actually require in terms of doctrine, methodology, and institutional practice? And what would antitrust enforcement that generally delivers for the consumers, workers, and competitive markets look like over the next couple of decades?
I think the main thing today is it requires more pointed evaluation of uh, technology, particularly big tech and especially digital tech on the internet. We need to quit blasting big firms just because they are big, just because they are engaged in a lot of different markets, and we have to start looking for practices that really do result in higher prices or lower output or some kind of competitive harm. Uh, and if we did that, I think we'd have a much healthier attitude towards digital markets under the antitrust laws. Now, I hasten to add, digital markets cause a lot of other problems too, right? They're abusive of children. They can be abusive of women. They can be uh, rife with fraud and other kinds of misleading uh, business conduct. Uh, and all of those things need to be investigated and prosecuted when they occur. But as far as antitrust is concerned, its goals are concerned with prices, output, and product quality. And there, I think antitrust could do a better job than it currently is of uh, assessing those practices accurately.
Yeah, thank you so much. And that was my last question for today. And I really appreciate listening to you. It really broadened my horizons on like the idea of antitrust law because I feel like when we're thinking about antitrust law, there's this very like anti-monopoly, anti big business and big firm like attached, like mindset attached to it. So like hearing your perspective on it really allowed me to understand different sides to both of the coin. So this has been a very interesting conversation with you. Thank you for the rigor that you bring to these questions, and also thank you for your academics and academia over the past couple of decades. I really appreciate like reading your articles and reading like your research has just been a pleasure to me. So thank you for making the time to join me today, and I hope you enjoyed answering some of the questions I asked.
My pleasure. Thank you very much.
Thank you.